Karen?
I will talk in regard to the Fair Labor Standards Act that began in 1938. It was in 1938 that the Fair Labor Standards Act was adopted and the Wage and Hour Division was established. And then under the 1938 Fair Labor Standards Act, the exemption from the child labor provisions of the Act would apply to any employee that was employed in agriculture outside of school hours for the school district where the employee was living while employed. So some years go by. In 1966, the Fair Labor Standards Act was amended, and it added the exemptions for family, employment, and hand harvest laborers. It also added a qualification that the child labor restrictions shall apply to an employee below the age of 16 who is employed in agriculture in any occupation found by the Secretary to be particularly hazardous for the employment of children below the age of 16. And there was an exception where such employee is employed by his or her parent or by the person standing in place of his or her parent on the farm owned and operated by such parent. The 1966 amendments also extended the minimum wage protections to certain farm employees, including minors whose employers in any calendar quarter of the preceding calendar year use more than 500 man-days of agriculture labors. And the overtime provisions of the law do not apply to farm workers. So a couple more years go by, and we have the 1974 amendments to the Fair Labor Standards Act. Those amendments retained the basic 500 man-day test for determining whether an agriculture employee is exempt from minimum wage and overtime coverage under the Fair Labor Standards Act. It also altered the method of calculating whether an employer used more than 500 man-days of agricultural labor. The 1974 amendments prohibited the employment in agriculture of all children under the age of 12, except those working, one, on farms owned and operated by their parents, or persons standing in place of their parents, or two, with the consent of their parents or person standing in place of their parents, on farms exempt from the minimum wage and overtime provisions of the Act by virtue of the 500 man-day test. In both of these exceptions, the children must be employed outside of school hours for the school district where they reside. Continuation of 1974 amendments. Children above the age 11 but below the age of 14 are prohibited from employment in agriculture unless such employment occurs outside of school hours for the school district in which they reside, and their employment is either with the consent of their parents or person standing in place of their parents, or they are employed on the same farm as their parents or person standing in place of their parents. Children age 14 and over are not prohibited from employment in agriculture by the child labor provisions of the Act as amended. And that's where we leave off with the 1974 amendments.